Good afternoon, everyone, and welcome to today's edition of The Law and You. I'm your host, Attorney Shellon Washington. I bring you areas of the law that affects you every Saturday at 4 p.m. Once again, good afternoon to those of you who are joining. It's a pleasure to be here again this afternoon. Today, we will be discussing medical malpractice and how it affects you. And today's edition of Medical Malpractice is directed to those people who lived in New York City and you were injured by the state of New York or the city of New York. Today, we are going to be discussing you because the rules that affect those who were injured, let's say by Kings County Hospital or any of those entities owned by the state of the city of New York, the rules are going to be different as they affect you. So let's get into today's program as we will discuss what type of rules you need to look to and how you need to maneuver yourself to get compensated if you were injured by a state entity or an entity that is owned by the city of New York. So let's get into it. Now, if you go to the hospital for some sort of sickness, or you go to a doctor's office, let's say a doctor's office, a clinic more specifically, or a hospital, and let's say you have a problem. Some people at times they get injured, or maybe they have, let's say, cancer, something really serious, and they go, and the doctor that they're seeing is either assigned to a clinic that is owned by the city of New York, because we know there's a lot of people out there who are on welfare, or you're accepting government sponsored Medicaid or Medicare. You're linked Medicare, more specifically, not Medicaid, because Medicaid is for those who are elderly over the age of 65. So let's say you're receiving Medicare, you're receiving social services from the state of New York, and you're sick and you're directed to go to a state owned or city owned entity with your illness, and they give you a specialist. If you go to a specialist, somebody who specializes in the area that you seek medical help, that person is supposed to be an expert in that area. But when you visit that doctor, the doctor gives you advice which is contrary to the standard, or they cause you to not seek further assistance. Let's say they did an x-ray, they did an MRI, and then they tell you, listen, you're fine, you need to go home, which often happens, with people when you're receiving social services. A lot of the times the doctor overlooks you. They don't take you seriously. So instead of doing proper examination, and I'm saying this because I've seen a recent situation where a female patient went to her gynecologist. The gynecologist did a superficial examination. She was later diagnosed with a form of cancer. And now that doctor who gave her the negligent advice, he is more likely to be responsible, because what he did a annual examination, and then when he was done with that annual examination, he sent her to do one further examination, and when that didn't show anything was wrong, he sent her home and said, you're fine. He didn't proceed to do anything else because he would argue that that's the standard of care. Now, any doctor you go to, there's a certain standard of care that that doctor must comply with once they're examining you for some sort of injury or some sort of illness. Once that doctor examines you, they have to follow a certain procedure and do something follow up. And then if they determine, based on the standard of care that they use, if they determine that nothing further is required, then they can tell you, okay, you can go home. But very often, even when the doctor follows that standard, people end up being injured. And the next step for you to do, if you find out that the doctor told you to leave, but a week or a month or 2 months after you develop more severe symptoms from whatever it is that you're suffering from, the next step for you to do is go right back to the very doctor that tells you to go home. Now, if that doctor again tells you, okay, you're fine, then you seek the opinion of a second doctor. When you go and you seek the opinion of that second doctor, the second doctor is more likely than not to tell you, okay, we need to do some further tests, blood work, whatever it takes to determine whether or not this situation is really as severe as it appears. So, what the doctor is going to do at that point is send you to do either more blood work, or if it requires like MRI follow up, or ultrasound, or whatever it is, that's what that doctor is going to do. And at that point, the second doctor who gives you the opinion is likely to find whatever it is that is affecting you. In the case of that female patient I mentioned earlier, yes, she was required to go to a separate doctor because her doctor that she was seeing for many years gave her the wrong advice. He misdiagnosed her, and then she ended up with a second doctor who actually determined that yes, you do have a problem and we do need to take some extra steps ASAP to save your life. One mistake by a doctor could result in serious injury or possibly death to a patient. So it's important that you yourself pay attention to your body to make sure that you don't feel anything different if something shows up in your blood work or on your annual physical, whatever it is you're going to get checked up for. And pay attention to it yourself. Always ask for a copy of your blood work. Always ask for copies of your medical record if there's suspicion that something might be wrong with you. The reason why you need to have that medical is whenever you come to me. So for instance, you suspect something is wrong, your doctor is telling you, your primary doctor that you usually visit is telling you, no, you're fine, everything is okay. If you request a copy of your medical upfront, when you go to a different doctor, to get a second opinion, based on that doctor, the second doctor's opinion, if the doctor said, yes, there is a lot wrong, and you do have cancer, or you do have something more serious, or something very, it's likely to cause serious permanent injury or death to you, then at that point, you could use that medical record and you can bring it straight to our office. Now, the reason why it's important if you're being seen by the city, I've said it before on one of my shows, but I'm going to tell you again now. The reason why it's super, super important to get advice, second opinion within a very short period of time if you suspect that you're injured or you're likely to die because of a misdiagnosis that a doctor gave you, and the doctor is working with a state or city entity, is because of the 90 days rule. Now, for those of you who are not familiar with the 90 days rule, if you're injured by a doctor, if you fall on the sidewalk on the street in the state of New York, if any type of injury that you suffered is a result of the city or the state of New York, the law says you only have 90 days to serve a notice of claim, except in certain circumstances where the claim is against the state of New York, then that timeline is for you to file your claim. 90 days to either serve a notice of claim or file that claim. Now, there's a reason for that rule when it comes to the state or the city entity. They want to make sure in the case of the city that the claim is investigated within a short time to preserve evidence, information, or whatever. And it also serves as a warning to you that if you got injured by a city or state entity, that it's really important that you move quickly to secure your right. Either you go yourself and you file your notice of claim, or you contact the attorney. You can contact our office and we will ensure that your notice of claim is timely filed within the 90 days. The law says if you don't file that notice of claim within that 90 days, you will lose the right to file that claim. And the people who are exempted from that 90 days rule is most likely to be like a minor or somebody who is insane. If you have a mental disease, mental illness, therefore you couldn't act rational, or you didn't have the mental capacity to file that claim in a timely manner, you might be able to file a motion to file the claim, the notice of claim that is out of time, or even file your claim. But other than that, if you don't move within that specific realm of time, you're going to lose your right to sue the state for any injury that the state would have caused. And I've also seen the situation other times where people didn't know. There was once a client who came to this country all the way from, I think, Trinidad, to file to seek the doctor's help. She ended up at Kings County Hospital seeking medical help. Once she got that help, they injured her. The doctor who she saw injured her. He committed malpractice on her. He failed to follow the standard of care, and he caused permanent injury to that woman. But by the time she discovered she was injured, she was out of time. The statutory period had already expired, and the city was aware of that. So there was no way she was going to recover. And by the time she got to me, it was already more than a year out of the time. She filed a notice of claim late, and then the 2-year statute it ran on her. So you got to be careful, and you have to be aware that with medical malpractice, two things must happen if it involves the city or state. First, the 90 days rule, you ensure that you comply with that 90 days rule in a very short span of time. Ensure that you get a second opinion. If something doesn't feel right with your body, you go to your primary doctor. The doctor does two different tests, which is most likely what they're going to do. A lot of times they do 2 tests and that's it. Or a lot of times they just really miss things, because in case some of you don't know, a lot of those doctors I've seen, some of them have started using Google. Some of them have started using Google. So if something is wrong with you, sometimes the doctor doesn't even pay attention. The doctor doesn't even do their homework to ensure that you're properly treated, or they look for all the signs in your blood work. A lot of things that is wrong with people, they don't know, but it's already in the blood work. But a lot of times the doctor, him or herself, doesn't know to read that blood work. So they miss the problem. Even Google in this day and age can help you read your blood work. Google gives you the range for blood test, or if it's an x-ray or MRI, Google could help you to interpret what some of those words mean, so that you yourself can become your own doctor to watch over your own health, to ensure that you stay healthy and stay alive. Now, like I said before, the 90 days rule is very, very important. It's critical, I must say, because once you miss it, it's gone, and the only 2 set of people will have the right to file a motion to file that notice of claim out of time is an infant, a child, person under the age of 18, or somebody who is mentally incompetent, so therefore they could not have complied with the statutory requirement. If you miss that deadline because you're neither an infant or an incompetent, somebody who's mentally incapable, then your time is up. You will not be able to file any claim outside of the 90 days against the state of New York or against the municipality. In that case, you might as well forget it, because you will never get compensated. Although the statutory period is 2 years to file medical malpractice, you're still bounded by the 30 days rule. And if you miss the 30 days rule, you might as well forget the 2-year statutory period, because the 2-year statute only applies really if it's a private entity. So if it's a corporation, a private doctor, all doctors, all medical facilities in the state must be insured. All of those facilities are insured with insurance. So they carry malpractice insurance on every person that holds a license. So on every nurse, on every doctor, on every anesthesiologist, every single person who holds a license is covered under medical malpractice insurance. So if you get injured, guess what? That insurance is what covers for your injury. And 98% of the times in most states, those medical malpractice claims are settled. It's never tried. The only reason why you really need me or any attorney to represent you on those claims is because you may not know that they are brackets, because we have something called the jury verdict. The jury verdict is what gives us an idea of what has happened in the past. If you know, people always say that you need to know your history. You need to know that history because it helps to guide you. It helps to give you information that you might be lacking. And if you know that history, it will help you make common sense decision. So the jury verdict is what tells us, okay, in a case where somebody died from cancer because of the negligence of a doctor, the range could be anywhere between 2.5 million to $10 million, or whatever the injury might be. The jury verdict is what gives us the guidance as to what you might be entitled to. Also, it could be based on our own experience as to what we settled similar cases for. So that's the kind of scenario you need to bear in mind as to why you need to get an attorney, because the attorney would have the knowledge and the experience to guide you and to be able to get the right settlement for you. And you shouldn't settle for just any attorney. You should always take somebody who has information, who has knowledge, and would be able to properly guide you. I've heard people talk about personal injury cases, going to certain attorneys and walking away with absolutely nothing or virtually nothing. So you need to bear in mind that when any attorney file a medical malpractice case for you, we bear the cost up front. So once that case is settled or end by way of trial, you have to pay back all of that cost plus 1/3 of whatever is recovered back to that attorney. If you had to do this on your own, chances are you would not have been able to. So as a based on the retainer agreement that you entered into with the attorney, you're going to be saying, okay, I have agreed based on that retainer to give you 1/3 of anything I recovered, in addition to give you back your costs. So I need to pay you back your costs. In New York, the calculation is a little bit different. They use a scale to determine medical malpractice fees, and you're paid back based on that scale on a rolling basis, and the percentage is there. So that's how your attorney is paid on medical malpractice in the state of New York. Any other personal injuries is just a contingency, and you pay based on the 1/3% that you've agreed. Most people are more likely to sign that retainer. But just so you know, there is a possibility that you could shop around and see what else is available rather than tying yourself down to those attorneys you see have their names on a billboard, or they have their commercial coming on the TV. They are more likely to charge you excessive amount for your out of pocket. And one of the things you will never be able to do is ask for bills or receipts from what was paid to the expert. Because as soon as you approach an attorney with a medical malpractice case, the first thing that has to happen is we have to send that file out to a specialist, somebody who specializes in the area that you have been injured in. So for a client who suffered because of a negligence on a surgery, let's say it's a prostate surgery, and it was done robotically, then we have to find an expert who's also specialized in robotic prostatectomy, and that surgeon has to review the file to determine whether or not the doctor fell outside the standard of care. If the doctor fell outside the standard of care, whatever the standard is, and that standard is determined based on the generally acceptable standard in the field, it could be seen in journals. You can get it from the doctor, the expert medical doctor himself, who is going to examine that file for the attorney to determine whether or not your doctor who saw you fell outside the standard of care. And a lot of times people are confused to what that standard is. So let me just be clear, not every injury that resulted from a surgery is considered a medical malpractice. So you should know that there are some injuries which are likely to occur from some surgeries. And if you agree to accept that surgery, you're most likely accepting the risk that comes with that surgery. So there's some generally accepted risk in every single surgery. And it depends on how common those risks are. Based on the commonality of those risks, that's what's going to tell you whether or not the injury that you suffered was one of the generally acceptable ones based on the procedure you underwent. So therefore, a risk of bleeding is always a risk in every single surgery, or based on how the anesthesia is administered, they will tell you some of the risk of going under the influence of anesthesia. Uh, the risk that we're talking about that would fall outside the standard of care would be some of the most egregious ones. It would be one that is not to the degree it's not expected. Like, for instance, let me give you a scenario. I have had a client with a robotic prostatectomy done to him. Now, we know that robotic prostatectomy are considered the most safest. It should be the safest type of prostate surgery. The reason why, it's bloodless. You're not being cut open so the doctor could go to see the prostate itself with his naked eyes and then remove it. So it's taught that by the doctor inserting cameras into your body, and the instrument by inserting portals, holes into your abdomen to see, and then using air to inflate your abdomen so that they can have ease in inserting those instruments, and then using the camera to see what they're doing internally. It is thought that those surgeries should be much, much more safe because the doctor is guided by a camera. So he's looking at the camera and he's moving the instruments in that person's body. Now, when the doctor is doing that, the doctor can seek a clear path to what he's doing. Now, if the doctor caused some sort of major injury, like he burns the urethra with such force, or he burns the rectum with such force, or he used the radiation heat. They use heat to cut through the tissue. They do not use like the regular instrument that would be used to cut through tissue when you're doing an open surgery. If you're making incision into the person's body and you're doing the surgery that way. Now, when they're using that heat, to that laser heat to cut through tissue, the doctor knows that he or she has to be careful because the laser heat has an afterburn effect. If you use too much of it, it could burn through the tissue at such a rapid pace that it will continue to burn even after you remove the laser heat from the person's body. So if the doctor uses that heat excessively, it is likely to cause an afterburn effect and leave a hole in organs in your body that the doctor was making the incision in. If that happens to you, that is considered malpractice, negligence, because the doctor ought to have the experience, the knowledge, and be able to cut through those tissues without using excessive heat to burn your tissues even after he removed the instrument or the device that he's using for the surgery. And like I said, if that happens, that is considered medical malpractice because the doctor, having the experience and the knowledge, ought to have known that he needed to use caution when making those incisions during the surgery. And therefore, the doctor would have fall outside the standard of care. The doctor would have failed to comply with the normal industry standard if they would have caused you some severe injury. Because it's normal that if the heat is burning and you have a small incision that cause a minor injury that can be easily repaired. But if it's something that is so major that it cannot be repaired, or it has to take multiple surgeries to even attempt to repair it, that doctor was negligent and need to be held so accountable for your injury. Whereas in any other surgery, I'm just giving you, that's just one scenario. Any other surgery where, for instance, there are people who underwent open heart surgery or some other type of surgery, and the surgeon left the instrument in their body and caused them to become violently ill. And they had to go back and do a second surgery and have that instrument removed. That again is a form of negligence. The doctor wasn't paying attention and failed to comply with the standard of care. And therefore, the law says that doctor is responsible for any pain and suffering you had to endure as a result of that negligence. Which brings me to one other point. You have to bear in mind, right, that if the doctor failed to comply with the standard of care and you suffered injury, you got the injury part is what you need to pay attention. You had to have suffered injury. Some people come and they say, I went to this doctor, they treated me for this, but I didn't really have any pain. I didn't really suffer for long. I went back to work within 2 days after the injury, or, if you didn't suffer any injury or any pain, you didn't go through any pain and suffering, don't even bother to consult the doctor. Because when the doctor failed to comply with the standard of care, you must suffer injury, damages in order to recover. If you don't have no damages, let's say the doctor forgot the instrument in your body and the next day you started feeling pain and they went in there and they removed it quickly. You didn't suffer for long. You suffered like maybe an hour, or maybe the hospital put you through an x-ray and realized it's still there and they took it back out and you didn't really suffer anything much. Then the law says you're likely not to recover anything or not much at all. It just depends on the degree, the extent of your pain and suffering. The more pain and suffering you go through, obviously, the more likely it is that you will recover a substantial amount. And also, recovery depends on a number of other factors, including your age at the time, your health condition at the time, the amount of wages you might have lost as a result of this injury and you having to recover from it after a surgery or after being in bedridden for a particular period of time. There are numerous factors that are put into consideration when it comes to medical malpractice. And just don't go and believe that every single injury, I said before, doesn't necessarily require damages. Not every single injury. You must have suffered some form of damages, pain, suffering. Those are the things that must happen in order for you to recover. If you didn't suffer, there's unlikely to be any recovery. So ensure that if you believe that you're injured, then you're going to seek the opinion of a second doctor. You're going to go take treatment, or if you need to undergo a major surgery to repair the damage caused by the negligence of another doctor, you're going to go seek the help of another doctor who's going to repair the damage or attempt to repair the injuries over either based on multiple visits or one or two. I don't know how long it's going to take for the other doctor who have the real skills and the expertise to repair your body is actually going to take for that doctor to complete that process. But it takes a while. So, if you have to take other treatments, you have to go to therapy or whatever it takes, you will have to go. And obviously, the more lengthy the treatment, the medical treatment to bring you back into your original state of health, the more likely it is that you're going to be entitled to a significant amount of damages for that injury. So again, to recap, because we're coming down to the end of this morning program of The Law and You, this afternoon program of The Law and You. So since we're coming down to the end, I just want to recap very quickly some of the things that we've spoke about today. And I want to encourage you, if you've been injured by any doctor or by a doctor that is controlled or working with a state or a city agency, medical facility, to give us a call. Do not wait at all. There's just one more rule that you need to know about as it relates to injury and the period to serve, or the statutory period. The one thing that you need to learn about is there is also what is called a discovery rule. So if you don't discover the injury until, let's say, a year after, the law says you can still move forward with the 90 days notice, because it's at the time you discover or the time you became aware of your injury. So if your injury was hidden and you didn't discover it till a year after the time you've seen the doctor, you can still use the discovery rule to recover your damages. But it has to be that it was really hidden. You couldn't tell because you weren't seeing any other doctor, you weren't feeling any signs or symptoms. But let's say a year after, then boom, the symptoms shows up in your body. And at that point, you're really forced to go ahead and file your 90 days notice. And chances are, if the city or the state objects, you can always bring a motion to allow your claim to move forward. Because of the discovery rule, you could not discover that injury until that particular time when you became violently sick. So once again, guys, thank you so much for joining me this afternoon for the law and you. And I want to recap again. The 90 days rule is important. It's important that based on your degree of pain and suffering, that's going to determine your recovery. Also, there's a contingency agreement where the attorney pays all the fees up front for you. And at the end of the case, that attorney is entitled to recover all of those fees they paid in advance for you for. So be careful. Know that although there's a 2 years of statute of limitations, when it comes to the city or state, there's a 90 days rule that you absolutely must comply with. Once again, thank you so much for joining me for the law and you this afternoon. And I have been your host here, happy to bring you this program. My name is Shellon Washington. And if you believe you were injured as a result of a doctor's negligence, feel free to give our office a call, and we'll assess your case and determine whether or not it's a viable claim or not. Just know that your claim always have to be assessed. We always have to send those files out to a licensed physician who determines whether or not the claim is viable. So once again, thank you so much for joining me this afternoon for the law and you. If you would like the phone number to my office, you can hang around. I will play this quick commercial for you. Thank you again, guys. Enjoy the rest of your weekend. And thank you for being here. So this is attorney Shellon Washington, owner and founder of the Washington Law Firm, located at 455 Utica Avenue in Brooklyn, New York. We're specialized in medical malpractice, personal injuries, matrimonial law, and landlord and tenant. If you're in need of legal representation, please give us a call today. The number to call is 718-877-3100. Consultation is free at no cost to you. So call us today to see if we can be of any assistance to your legal needs. Again, the phone number to call us is 718-877-3100.